Hello everyone, and thank you for joining us for today's Ius Laboris client webinar on coronavirus workforce management in the Americas during COVID-19. My name is Annie, and I'm the Business Development Coordinator at Ius Laboris, and I will be facilitating this session for you. Our presenters today are all lawyers from the Ius Laboris firms in the United States, Canada, Brazil, and Argentina. I will now hand over to our first speaker, Jeff Makata from the United States. So go ahead, Jeff. You're welcome to start.
Yes. Hey, thank you. And good morning, everyone, or good afternoon for those joining in the afternoon. What we're going to be doing is a little bit of speed dating. We're going to have 4 different country perspectives from us, from Canada, from Argentina, and from Brazil on 3 overriding topics. And the first topic that we're going to be handling is where are each of these countries now in terms of returning to work, if at all. And I am going to start with the U.S. perspective, and for those familiar with the U.S., both politically and otherwise, we have an idea from a federal level and an idea from the state level. And from the federal level, our president is very much focused on trying to get a return to work as quickly as possible. He's butting heads not only with our CDC, but also with various state governments. And what you can see in the United States is a patchwork quilt of philosophies based on where you are and what business you're in. And I mean, I can give you an example in terms of what we here at Ford & Harrison, our firm, is doing. For example, we had yesterday a firm-wide webinar where we talked about which states were going to be returning attorneys to the office coming this Monday and which states weren't. For example, where I sit right now is in Atlanta, Georgia. We've had for the past couple of weeks people in and out of the office already. Juxtapose that to New Jersey, New York, California, Connecticut, where we have offices, also in Chicago, Illinois, and they're months off potentially from returning to the workplace. So you have to look at where primarily your headquarter office is located in the States to get a better vibe of what that company is likely doing, and then also the type of business. What each of the states and cities and sometimes towns have done is have their own what they call shelter-in-place order, and those shelter-in-place orders vary widely. For example, here in Georgia, as of the end of April, 3 very important industries were to open up for business, that being tattoo parlors, bowling alleys, and nail salons. And so using that as a starting point, the following week, some of the restaurants were opened, and the governor identified 39 requirements that restaurants must adhere to: wearing masks, having certain protections in place, other PPE in their shelter-in-place orders. And again, you're going to see in some states shelter-in-place orders that are really prohibiting all but the most essential businesses from conducting business. And those essential businesses in a place like New York City, for example, primarily focus on the healthcare industry. Some states are requiring return-to-work plans, like Indiana, meaning that the companies must, pursuant to these shelter-in-place orders, put in a handwritten return-to-work plan that follows what the shelter-in-place order requires, and then others are more suggestive. If I look, for example, at Georgia's most recent shelter-in-place order, there is a large focus, as there is at a federal level, on the vulnerable population defined by the CDC, the Centers for Disease Control, and by the federal government as anybody who is 65 and older, and then enumerated healthcare conditions that make you more vulnerable. Those individuals in every jurisdiction are still, or in most every jurisdiction, are still required to shelter in place, not return to work, all but in the essential businesses. So I'm going to hand it over right now to my good friend in Canada, Sonia. And Sonia, please take it from there.
Thanks so much, Jeff. So in terms of, there's some similarities to what's happening in the U.S. in that we in Canada both have federal legislation as well as provincial legislation that is governing the current status of the government directives. Early on, the government directives closed most businesses. Provinces and territories in Canada were then individually responsible for determining which businesses were permitted to reopen and when. In Ontario in particular, as of today, Ontario's extended the declaration of emergency until June the 2nd. However, what has happened that is important is that the list of essential businesses and those permitted to operate using curbside pickup and delivery are expanding. Construction activities also importantly that are permitted to proceed are expanding. Things like provincial parks and conservation areas are reopening with certain conditions. So this is a movement to begin reopening at the provincial level. And again, as Jeff mentioned, which is important in the U.S. context, it's also important in the Canadian context. Depending on the province in Canada in which you operate, there are specific rules. And Matthew Dinsdale has been providing updates as we have offices in a number of provinces across Canada. We've been providing updates on those provincial governmental directives and the list of essential services and those other services permitted to reopen as of now. Also at the federal level, important to note that financial relief is available to businesses struggling because of closures imposed by government directives and or those businesses that are otherwise negatively impacted by COVID. And we're seeing that financial relief is retroactive to the middle of March. And so that's also a very positive development to help businesses who are struggling at this time. So I'm now going to pass it over to my Brazilian colleague.
Thank you. Good morning, good afternoon to all. I would like to start with a catchphrase that once a famous journalist pronounced, which is, Brazil is not for beginners. And why so? I think we are very good at improvising, but not so good at planning. So it's hard to tell exactly where we are. As you can see from the figures in the slide, numbers are still increasing in Brazil, so we would probably have not reached the peak of contamination. And yet, at different levels, we have the president saying that we should reopen the business as soon as possible, whereas some governors, depending on the region, will tell you otherwise. In São Paulo and Rio, governors are being more restrictive in terms of opening up businesses. And at municipal level, we still have also mayors who are imposing very severe restrictions in terms of mobility, closing the main roads to the cities to avoid people coming in with a possible risk of contamination. So at the end of the day, it will depend a lot on venue and on geography to determine if your business in Brazil is prepared to open or not. At the three different levels, what we have is a general command by the federal government determining what are the essential activities. and then state governors will stipulate certain operational restrictions, such as closures, for example, or partial operation, and especially to restaurants and shops who may have takeaways or delivery services. And the more severe ones we see are determined by mayors in the municipalities, some of them with already complete lockdowns. In the northern part of Brazil, where the outbreak is more recent than in the south, some mayors have determined the complete lockdown of their cities. I think the best example of such conflict between federal, state, and municipal level comes from a decision made just yesterday or the day before by the federal government. The president has amended the federal decree that lists the number or lists the essential activities that may be operating during the pandemics to include beauty parlors, barber shops, and gym clubs. And immediately after that, the governor of São Paulo said he will not follow the decree, that the situation in São Paulo is critical and such services should not be treated as essential. So as you can see, Brazil is really not for beginners. You should look for specific regulations on the state or the cities where your operations are in Brazil. And with that, I pass it on to my colleague, Veronica, for Argentina.
Thank you very much, Jose. Good afternoon or good morning, everyone. Well, in Argentina, we are still in what is called the preventive and compulsory social isolation period. This period has been imposed the 20th of March and is still in force until, in principle, the 24th of May. There's, as in all the countries that have this kind of measures, there's a general restriction of the freedom of movement applicable to all residents, but lately this measure has been moderated for a territory of Argentina, except for Buenos Aires, the biggest city of Argentina and its metropolitan area, since it is there where the 86% of COVID contagion is taking place. So nowadays, and in general terms, no cultural, recreational, sporting, or any kind of event with public attendance can take place. There's no schools, no touristic activities, and exceptions to these restrictions have been going on since the very beginning based on the criteria as in Brazil of the essential and non-essential activities. Those exceptions guarantee that persons working in essential activities can attend to work, for example, security forces, health personnel, persons of the administration, etc. This compulsory isolation period has been loosened down during the last week, as I already told. The federal government has empowered local authorities with the prior approval of the Ministry of Health to permit the resuming of certain activities in certain locations. As a consequence, it is estimated that nowadays these new permissions to resume activities will boost local economies up to 55% of their economic capacity. There are certain prerequisites to follow to resume activities. For example, there must be strict safety protocols we will talk about later, and certain epidemiological parameters have to be met. For example, there has to be a significant decrease of contaminated persons. The local authorities have to guarantee the capacity of the health system, the local health system, to respond to the health demand. The number of people exempted from the isolation period has to be lower than the 70% of the total population of the location. And the specific location has not to be defined as a local transmission conglomerate. Those exceptions cannot include the reopening of schools or public events in general, or places in which there can be crowded easily. Departments where there are more than 500,000 residents may allow certain industries only if for that industry or activity there is a safety protocol approved and listed in a special applicable regulation for this period. And for a city of Buenos Aires, as I told before, the biggest and its metropolitan area, the authorities, the governor of the province of Buenos Aires, the governor of the city of Buenos Aires, have to ask for a special permission to the federal government to allow for exceptions and, of course, guarantee two things, very important things, the existence of a safety protocol and that the employers who are resuming activities can guarantee the transportation of the employees to the facilities. Those measures are continually being monitored and they are valid in principle until the 24th of May. Well, now I will hand over to Chef. Thank you.
Thank you. So the next topic that we'll all be discussing is the reopening and some of the issues that companies are facing if you're at the reopening stage. And I really lump these into two overarching umbrella issues, which is is there going to be resistance by the employees to returning, and will there be resistance by the employer to returning the employee to the position? And under the employee resistance umbrella, one of the primary issues in the United States is the unemployment benefits that are very robust right now. More specifically, under a new act called the CARES Act, in addition to what you would get if you are furloughed or laid off temporarily, or if your hours are reduced in some states, you would also get an additional $600 a week through July 31st of this year. And so I use an example here. In Georgia, someone could get approximately $1,000 a week in unemployment benefits. In Massachusetts, which has the highest state unemployment, you could be getting a little over $1,400 a week, or about $74,000 a year if you were to annualize that. So there's a real incentive by some employees who are getting paid more now in unemployment than they would in their current jobs to stay home. And yet, each of the state departments of unemployment and certainly the federal government have been very focused on getting folks to return their employees to work. So you really have two choices, because generally if a worker refuses to return to work after giving reasonable notice, they don't have a job. They're likely not qualified anymore to receive unemployment benefits. So a pure stick approach of saying you need to return or else you don't get unemployment is what some companies are doing. But other companies have to deal with the fact that some of their employees have unique or special skills and they need them now in returning to work. So what carrots can they provide? And some of our clients are using bonuses that they might call hazard pay. They might increase their pay at least through July 31st, 2020. So you're seeing a variety of approaches there. And then when you have employees that have been, and there's large populations that have been working remotely and therefore not collecting unemployment, but rather are teleworking, do you continue that? How do you continue that? And the issues that revolve around teleworking. And then, of course, ensuring or trying to ensure as much as possible to each of their employees the safety that the companies are undertaking. And in that regard, you're seeing temperature checks. You're seeing limited testing right now, mostly in the healthcare industry. And you're seeing return to work questionnaires, which generally ask questions about health and safety and travel to determine whether they should continue to quarantine or not. In terms of not having your entire workforce returning because you realize that you might need that workforce, I use a quick example of one of my large restaurant clients, which in February of this year had about 2,200 employees. As of April, they had 12 employees. And restaurants are going to take a long time in really any country, but certainly in our country, to return to their normal. So they're having to determine how many folks they're going to bring back. They're going to have to rank and identify who are their best performers, and that creates a whole host of issues, which I will save for our last bit. And now I am turning it over to our friends in Canada.
Thanks so much, Jeff. So in terms of reopening, because of the medical research around and the public health guidelines around the significance of a COVID viral load as being connected to whether an individual suffers from the illness and the extent to which they suffer, one of the main considerations and one of the main facets of the guidelines in terms of reopening business and returning employees to work is the maintenance of the physical distancing requirements. It is our expectation that those physical distancing requirements will remain in effect for at least the short to medium term. And as a result, an important consideration for a company is that the employer may not be in a position to return all employees to work at once. And so that this is something that has to be considered as to how the physical distancing requirements can be respected once the business is reopening. Also, employers are required to provide personal protective equipment, which we're calling PPE here in Canada, where physical distancing cannot be guaranteed. So that's things like masks and gloves. In addition, appropriate sanitation precautions must be implemented. And we are in possession, there have been, the government has published a number of sector-specific guidelines with respect to the appropriate sanitation precautions that must be implemented. In addition, and importantly, employers can benefit from the Canada Emergency Wage Subsidy. And this is a federal subsidy that's designed to cover up to 75% of employees' wages for up to 12 weeks, retroactive to March the 15th, and at this time up until June the 6th. And that is a certain cap in terms of what will be provided. This is a clear incentive for companies to either continue to employ those employees that they have been employing throughout this period of time, or to bring employees back to work. And there are certain rules around employees having to have worked for 14 days so that the employer can qualify for the Canada Emergency Wage Subsidy to cover those wages. But that's certainly an important consideration that may assist in the reopening of a number of businesses. And with that, I will turn it over to Jose Carlos in Brazil, please.
Jose, you might be on mute. We cannot hear you.
Actually, I was, thank you, Sonia. I was waiting for my slide to move, and it just moved now. Thank you. Reopening in Brazil depends on, again, the stage where your business will find itself depending on location. As much as we have different or three levels, federal, state, and municipal, in terms of legislation to face the emergency of COVID in Brazil, employment and labor laws are exclusively federal. The federal response came through two provisional measures at the beginning of the pandemic. Two measures, numbers 927 and 936. 927 was the first one, and it addressed small rearrangements on existing mechanisms to manage workforce that would fluctuate or need to adjust to moderate quarantine. For example, you can use telework, which are all your employees on home office, if that is feasible from a business perspective, or you can have holidays anticipated or have special rules for the what we call the hour account, which is the set-off mechanism to balance time off and overtime. The most important one, however, came later. It's Provisional Measure 936. It addresses suspension and reduced work hours and salary. The maximum terms for each are respectively 60 and 90 days, but the company is able to bring forward the date if they need to resume operations or reopen earlier than that. Extension is unlikely to happen. The government probably will not extend that, especially because the federal government wants economy to start or to bounce back. But if in the unlikely scenario that situation aggravates, perhaps this might be a necessary remedy. In terms of restructuring that comes from the reopening, most of the clients are curious about what about redundancy? Is it possible to terminate and dismiss people? Well, this is a tricky question. I'll try to be concise, even though the answer might require some elaboration and a review of the specifics. But generally speaking, dismissals are not forbidden. But we have a tradition in Brazil that collective dismissals, and we don't have a framework for that. It depends on the value and number of employees as compared to their impact on the community. Depend on collective agreements, depend on arranging for the mitigation of social impacts, which becomes particularly sensitive at this time or at this moment where the pandemic is still hitting the society very hard. And we see some courts that are, as we will address later, but we see some courts that are very protective of employees in that regard. But still, after the expiration of both provisional measures, the labor code still contains remedies that are available at any time of crisis or any crisis that is business specific. You can, for example, change full-time employees into part-time. That depends, of course, on collective agreements, as most of such special arrangements or different structures, and individual enrollment. The employee must voluntarily enroll into that plan. And we also have, even after expiration of Provisional Measure 936, the possibilities of suspension and reduced work hours. They will not have the same funding or social benefit paid by the government, but still they are possible under collective agreements. And with that, I hand over to my colleague Veronica for Argentina.
Thank you very much, Jose. Well, Argentina is going through a long-lasting recession. This is the economical context in which the reopening of activities will occur. It is expected that the economic downturn reaches up to 5 or 6% of our GDP. Nowadays, we have over 60% of our industrial capacity under stoppage, with a gross sales drop that affects 65% of the businesses, even essential activities, those that have been working through the very beginning of the isolation period, are working with reduced staff due to the number of people, employees, following under the categories of risk people or risk groups like aged people or people with pre-existing diseases that are exempted to attend the workplace. So this is a very difficult context for the employer. And in addition, we have a very particular legal framework because according to a recent decree, dismissals without just cause and those on the grounds of economic reasons or force majeure are absolutely prohibited. So are suspensions on these grounds. Consequently, employers now cannot go through massive restructuring, and their reorganizing power is limited just to the reorganization of the work schedule or, of course, termination by mutual agreement. Besides, in January, when the new government took over, there's an aggravated compensation for dismissals without just cause that duplicates the compensation that is in our labor contract for this type of dismissals. And this measure is supposed to last for a period of 180 days, but we don't know if it could be extended. So in this context, and if employers want to make collective restructuring, because of course the economic situation may put several constrictions to resume activities as they were before, the only way to do that will be through what is called the crisis procedure, which is a special procedure applicable whenever collective redundancies for economic reasons are intended, but only, of course, if the measure that prohibits dismissal that should be ending by the end of May is not renewed. This crisis procedure entails the presentation before the Ministry of Labor, who will take a role of a moderator in a consultation period with the union representatives and, of course, the representatives of the company, in which the company will have to disclose their economic and financial information, including the results of the last exercises, the list of employees to be dismissed, and the proposal to pay severance. If no agreement is reached during this consultation period, the company can proceed with the collective redundancies, and they will have to pay the 50% of the compensation due to any dismissal without just cause. If the procedure is not complied, dismissals can be challenged and considered null before the labor courts. And of course, as the union intervention is unavoidable, there's always the possibility of collective actions in case no agreement is reached. With that complete context, our employers will have to start to reopen. And I think that now I can hand over to my colleague Jeff for our last topic.
Jeff, you might be on mute.
Yes, thank you. I think some people would like me on mute, but in any event, our last topic is going to be the key issues going forward. And in the United States, the land of lawsuits, we're already seeing, I wouldn't say yet the floodgates have opened, but we are tracking at our firm the number of COVID-19 lawsuits that have already been filed, and of course they all relate in some regard to someone who was either terminated or not called back to work allegedly because of something to do with the coronavirus. And so when we're looking at, as I was discussing before, if we look at the umbrella of employers not returning all of their employees, one of the primary issues and concerns that a company needs to address is developing an internal group that can look at, from an objective process, those individuals who they are selecting to not return, to ensure that, or at least to ensure as much as possible, that it is not challenged on the basis that it is discriminatory or retaliatory. And while it is always easiest to use objective criteria, like a last person hired is the first person fired, that's rarely good for business, and so there's always some limited subjectivity, but it's a focus on developing a criteria that identifies your better performers, that identifies necessary components of your business, and that process is documented internally, potentially through your in-house attorneys or outside attorneys, to ensure, to the extent possible, that certain information is privileged. you need to consider whether to conduct what's called a disparate impact analysis, where you have an outside entity run a formula to determine whether there is an adverse impact on a group or population that's protected, like those above the age of 40. And that is something that is typically done to ensure against discrimination and retaliation issues. In particular, some of the acronyms that we'll be talking about now are the Americans with Disabilities Act, otherwise known as the ADA. And when someone may contract the coronavirus, there hasn't been an overt definition from the agency tasked with enforcing the ADA as to whether having COVID-19 can be a disability, but if you regard someone as being disabled, that could sometimes violate the ADA. So we have to be careful of claims under the Americans with Disabilities Act when selecting who returns. And then the most common claim and the most difficult claim in the United States to defend against are the generally lumped retaliation claims. And like my colleagues, we have any number of old acronyms we have to worry about and brand new ones, like the Families First Coronavirus Response Act. And that the FFCRA applies to any company who had 500 or less employees, and if, for example, someone is out on leave to take care of their child because school was out and you elect not to return that person, you may suffer an FFCRA retaliation claim. So again, it's looking carefully at who's being selected to return and who is not. As we've talked about throughout this presentation, each state may have its own requirements. Some states like New York and New Jersey and Illinois, when they have essential businesses conducting business right now and going forward, they're going to be required to pay for and mandate the use of masks upon returning to work. And then if you end up providing severance, a separation pay to your employee, which as a general principle is not required in the United States, but if you do offer some form of separation pay and it is to 2 or more employees who are being let go because of a reduction in force, you have to be aware that we have unique laws at a federal level in this country that require certain data, primarily data based on the age of the employee, be shared with the employee before having a valid separation agreement. And there are plenty more issues, but I tried to highlight some of our key issues in returning. With that, I am going to forward and send this over to Canada.
Thanks, Jeff. In terms of some of the key issues going forward in Canada, keeping in mind that when employers reopen or those essential businesses that have been operating during the government directives, if they're increasing their business activity and their business levels, again, keeping in mind that the overriding issue is employee safety, there are a number of issues that all companies should be considering at this time. The first is that employers should be implementing policies regarding access to the workplace and considering whether restricted access is necessary. For example, restricting access only to employees. What do you do if you have a customer-facing workplace location, for example, in retail? How do you safely restrict access in such a case? So consideration has to be given to the access to the workplace issue. In addition, employers should be implementing policies regarding employee screening. So for example, employees may be screened for symptoms and asked to complete screening questionnaires. There is guidance, there is governmental guidance about the appropriate questions that can be included in such a screening questionnaire. We've been asked a lot of questions recently about whether employers are permitted to install tracking devices to the extent that such apps are developed and are found to work, in fact. This clearly presents very significant risks in Canada from an employment as well as human rights law perspective. And so that's an area that we expect to continue to get questions, but that is a serious red flag. In addition, employers should be implementing policies regarding physical distancing. As I mentioned before, physical distancing will be an obligation that will be required to be maintained, and that may be considered by reducing the number of employees in the workforce, in the workplace, reducing the number of in-person meetings, for example, staggering start and end times, lunch breaks, to prevent a large number of employees either coming and going at the same time. In addition, other policies need to be considered, such as how is the company going to deal with contractors? How is the business going to deal with customers? And having a clear policy that can be provided to both contractors and customers and suppliers regarding attendance at the workplace and the company's screening policies is very important. Finally, a key issue going forward is going to be also employers considering how to address and manage employees who are not prepared to return to work because of the risk that COVID presents, even when the business reopens or when the business activity increases in the case of businesses that have been continuing. So how do you incent employees to come back to work, and how do you address and manage those who refuse, taking into account the company's obligations under human rights legislation and its obligation to accommodate disabled employees? As a final point, something that we expect to be watching closely, I read this morning that in Denmark, illness from coronavirus can be considered an occupational injury. So this is also something that we're watching very closely in Canada to see whether a similar approach is developed. With that, I will ask Jose Carlos to take the floor.
Thank you. Well, in Brazil, companies have to cope with a dilemma. They, on one side, they have the duty and the obligation to look after employees' well-being and with the general work conditions. They have the duty to implement orientation, education, and keeping social distance within their workplace. Provide physical barriers, masks, sanitizing materials, all that, similar to many other countries. But on the other hand, they have to deal with the first, the employee's right of refusal to go through exams. The company cannot force an employee to go through temperature scanning. It must be a voluntary participation. And if the company comes across an employee who is suspected or has symptoms of COVID, the only thing that a company can do, and in fact it must do, is ask a occupational doctor to examine the employee and put the employee on medical leave, as the case may be. But there is not much the company can do to force or induce employees to follow more strict rules that could be, or more strict procedures that could be considered invasive of their privacy. And also, they must be cautious not to be in violation of the new law we have for data privacy, because they're not supposed to collect medical data. The data concerning medical conditions are a strict business of occupational doctors. But I would like to use my time to mention exactly what Sonia said as a closing remark, is COVID, an occupational disease in Brazil. There was a recent judgment by the Supreme Court that indicates it might be so. In fact, Jeff said that the U.S. is the land of lawsuits. Well, Jeff, challenge accepted. I think that we in Brazil hold the infamous record for individual labor litigation. We had some 4 million in 2016, 4 million new cases in 2016 only. And although the number has decreased in 2019, we had some 2.6 million. And I suspect that after the COVID crisis, there will be much more, either because of layoffs or because of this particular issue. Well, the rule in Brazil is not of strict liability. It's rule of burden of proof of causation. The employee must prove that the disease was caused by contamination within the workplace or commuting, because accidents or contamination in commuting could be work-related. What the Supreme Court did was to outrule a very unnecessary provision from Provisional Measure 927. The president decided to somehow confirm the rule that causation needs to be proven. But in a nutshell, it was really inconstitutional. It was a provision that, in fact, addressed matters of civil liability which are not suitable for that particular text of law. So what the Supreme Court said did not change the rules in Brazil, but it certainly provides labor courts and lower judges with some comfort to determine causation based on circumstantial evidence. It is almost, if not actually impossible, to determine exactly when and where the employee got contaminated. But circumstances might show that if co-workers were contaminated, then circumstantial evidence might be sufficient to rule the case. And I expect that this will be a much mitigated matter in the upcoming future. With that remark, I pass on to my colleague, Veronica.
Thank you very much, Jose. I will start with this one because I will take over from this last issue. Is COVID an occupational professional disease or not in Argentina? But in Argentina, we had a really draconian solution, which is that our government has recently included COVID-19 in a list of professional and occupational diseases that it is released by our authority in those matters that depends on the Ministry of Health. So up to this moment, COVID is a professional disease, but it has to be proved that it was contracted at the workplace. So there will be a bit of litigation there also, but if it's the first thing that the employer has to do if an employee is supposed to have been contaminated by COVID at the workplace or commuting is to denounce such circumstance before the insurance company that cover the health risk of his employees and go with a special proceeding for that purpose. If it cannot be said that COVID was contracted at the workplace, yes, the COVID will be considered a non-occupational disease, of course, but the employee will have to grant the medical leave that it is provided in our labor legislation, and the employee will be entitled to the regular salary payment, which in case of the COVID is considered an occupational disease, will be in charge of the insurance company. The employer is entitled to screening and to ask for information to the employee about the symptoms, the possible symptoms that they may have of COVID, or if he has been or not in contact with people infected, and the employee cannot neglect such an answer. It's obliged to inform immediately also if he has any symptom of the infection. And going back to the first one, the employer, is being encouraged to make a substantial reduction of the presence of personnel when resuming activities in the workplace. That is to say, teleworking is being encouraged throughout the country and throughout all the industries. Though it should be pointed out that in Argentina, recent studies have shown that the percentage of jobs that can be potentially carried out from home are between 27 and the 30% of the total work performed, figure that drops dramatically if we take into account the number of households with effective use of computer and internet. To finalize, and similar to what my colleagues have said regarding safety measures, there are strict protocols at different levels, protocols that come up from national authorities, provincial authorities, municipalities, and even employees that have to be complied with very strict measures. The measures that are well known, such as social distancing, the provision of disinfecting products, the training of measures to avoid COVID, the avoidance of contact with people that can have symptoms, etc. And lately, an app for the mobiles to be uploaded in the mobiles of the employees have been released to diagnose and also to provide employees with the authorization to circulate in order to attend the workplace. That would be for me all. I think that I will hand on now to Sonia for the Q&A stage. Sonia, it's all yours.
Thank you. Thank you, Veronica. Thank you for highlighting those important issues in Argentina. So we have some questions from the audience, and we've only got a few minutes left. I understand we'll all get thrown off of the webinar at 11 a.m. So let me try to be quick in terms of moving through the questions. The first question that I have is for Jose Carlos. The question is for Brazil, and it is whether a furlough or furloughs are possible in Brazil. Jose?
Yes, thank you, Sonia. Well, I'm afraid they're not. Part of our protective system prohibits that. Companies can grant to employees paid leaves or under the provisional measure 936, they may up to 60 days suspend the employment agreement, and employees will collect part of the Social Security and employment payments, but furlough, as you know, are not permitted in Brazil.
Thank you, Jose Carlos. That's very helpful, and thank you for being so succinct in your answer. That's not always easy to do for us lawyers. The second question is, Veronica, for Argentina. Whether in Argentina the measure of prohibiting dismissals is expected to be extended.
Okay, that's a good question. In fact, we don't really know what's going to happen. I've just read in the newspapers this morning that our main union branches are putting too much pressure on the government for the extension of such a measure. We don't really know, but it's likely that it will be extended. It was formed to be a short-term measure of 2 months. Probably will be extended. We are not sure, but it's likely, as I said before. Thank you, Sonia.
Thank you, Veronica. The question that's come in for Canada is asking about whether or not there are issues related to an employer collecting information through the surveys, the screening surveys, regarding an employee's personal health information, and whether this raises issues regarding data protection or the protection of employees' personal health information. And I'm going to give you very much a lawyerly answer to that, in that it is of high concern. So in Canada, in short, employers have very limited rights to obtain personal health information about their employees. And so there are very specific rules about the kind of information that an employer can collect when assessing an employee's ability to work. And so in these circumstances where it certainly is possible to create a screening questionnaire that will likely withstand scrutiny and will not violate any of those employee personal health medical protection requirements, but it is certainly something that has to be done with care, and information that is collected has to be done with care. So that would be something to engage in very carefully, and certainly with the guidance of your legal advisors and your human resources advisors. Turning to the last question for the United States, Jeff, this question is for you. What is the Paycheck Protection Program, and how does it relate to returning employees to work?
Sure. Thanks, Sonia. Paycheck Protection Program was instituted just about a month ago, and what it does is for companies that have less than 500 employees, and there's a number of rules that make exceptions to that, but bottom line is they are able to apply for a loan from the federal government that is fully forgivable, which equals 2 months of the company's payroll. And so over the past several weeks, thousands upon thousands of companies have received their substantial check from the federal government, capped at $10 million, and now they have to spend it. And the way they spend it is 75% of the funds received from the federal government must be used for payroll, and there's any number of definitions and exceptions to what is or what constitutes payroll, and then 25% of it can be used for rent and utilities. And if you don't use it all, you have to return it, or you can keep it as a loan with a 1% interest rate. So there is a lot of strategy in how you're using it. Its sole or primary purpose was to encourage companies to retain their employees on the payroll. And so companies are doing just that. And if they're not returning folks, or if folks don't want to return, they don't necessarily have to count those employees. But the bottom line is it's yet another acronym that we as employment attorneys and you guys as employers have to be aware of in terms of thinking about how to return your employees to the workforce.
So much, Jeff. Another important piece of the puzzle, it sounds like, in the U.S. scheme of regulation and subsidies. Thanks so much for that summary. So with that, unfortunately, we don't have any more time for questions, but I am going to turn it over to Annie to wrap up. Thanks so much, Annie.
Thank you, Sonia. So we are conscious of time, so we're just going to wrap up next. So if your question didn't get answered today, you can contact the presenters directly by email as well. If your query is, however, related to a different jurisdiction, you can contact me at annie.laxo@iuslaboris.com or go to the people pages of our website to find the right contact. For some insightful information and further updates on the coronavirus, I recommend you visit the Ius Laboris Corona page, which is regularly updated as the situation evolves. From there, you can upload our coronavirus guide for international employers with information from 58 countries. So finally, I would like to thank everyone for attending today, and thanks also to our presenters for all of their insights. So with that, this webinar will now be ending. Thank you.